Hello, and welcome back to Hagan's New Jersey PIP Tips, where we bring you monthly segments on New Jersey auto insurance personal injury protection, otherwise known as PIP. This month, I'm going to go back and look at the appeals process again that became effective April 17, 2017, as the issues are starting to appear in arbitration now. Although the insurance carriers might have tried to soft sell it at first, they're starting to get with strict compliance. So I'll be answering some of the questions that you've forwarded to me and hopefully make the process a little clearer for you. In addition, we'll be doing the monthly drawing and of course wishing you a very happy Thanksgiving. Let's get to it. I thought it was very important to go over revisit the appeal process as the issues starting to pop up in arbitrations where the defense carriers, insurance carriers are trying to argue for strict compliance more and more often, whether it's timing, the form, the substance, etc. So I asked you for a bunch of questions and I did get some back, and I regularly get them. As always, we're here for you. If you have questions, don't be afraid to jump on the phone or shoot me an email. For more information on the appeal process, you can check out my prior videos, particularly numbers 13, 16, 18, and 26, with 18 really covering the soups and nuts of the appeal process. So I want to go over some basics and then answer some questions I've gotten from you, the medical providers. So again, you must follow the new appeal process, which took effect April 17th, 2017. Now, it was supposed to be a consistent appeal process across the board for all the carriers. Unfortunately, the Department of Banking Insurance, under a former director leader, was approving plans with different times and different requirements. But parts of it are consistent. If you want to proceed to arbitration directly on your behalf and use the assignment of benefits you must follow the appeal process. They're going to look for technicalities to kick the otherwise valid arbitration out based on these. So make sure you read each plan. Each insurance carrier has their own plan. So I recommend for each claim that comes in, make sure you get a copy of it. They're required to send it to you, and read it and confirm the dates and times and addresses and things of that nature. So not only do they differ from company to company, companies can change them and often do. They'll update them, add new numbers, new mailing addresses, new vendors. So make sure you're checking that specific plan and don't just dump to a default. There are two types of appeals. There's a pre-service appeal and a post-service appeal. The intent of the regulation is you only have to do one of these for each issue. So if you get a pre-service appeal is for when you get denied when you're requesting your pre-certification of treatment. So you're about to you see the patient, you determine a treatment plan, you send in your prior notice or pre-certification, and if they deny it by a medical director review or whatever reason they deny it in terms of pre-certification, then that would be a pre-service appeal. You have to file that appeal within 30 days of the receipt of the denial. If it's not a pre-certification denial, perhaps you're getting approved for treatment, but they're not paying some of the codes, or they're paying them improperly, and you get an explanation of benefits that leaves something unpaid. That would be a post-service appeal, and there's a separate form, requirement, and timeline. If you do a pre-certification, and this is, I want to clear this up even though insurance carriers are trying to, in arbitration, apply it differently. There's only one appeal process required depending on the issue. If that issue changes, however, so for example, if you get denied a pre-certification, you do your appeal and they continue to deny it and they never pay it, that one pre-service appeal is sufficient. If, however, they deny it in pre-cert, you appeal it, they either continue to deny or maybe they reverse their opinion and say, all right, we're going to allow it now. But then they don't pay it correctly through the explanation of benefit. Maybe they try to apply a penalty or not pay an individual service or pay less than fee schedule. Then you would have to do a post-service appeal. But again, so if it's the same issue from pre-service until after your service is performed, then it's only one. If it changes the issue, then you got to do a separate one. If you want to be extra safe so that you never have arguments, although it's going to take extra work, you can do a pre-service appeal and a post-service appeal on those services that are denied in pre-certification, and then you get an EOB that also denies it once you bill it. But that's not required, but it's just being extra cautious. I should point out though, in both the pre-service and post-service appeals, you have to use this specific form that's been approved by DOBI. Now, the carriers are required to send them to you with their decision point review plan, but you can also obtain it off the internet at the website listed below, Adobe's webpage. They specifically have it for health information for providers, and we'll share that link right there. So make sure you're using the right form. If you're not using the right form, that's going to be a reason to throw out your otherwise valid arbitration. So let me get to some of the questions I have, and I kind of addressed a little bit of them. Do I have to file 2 appeals, both post-service and pre-service? I kind of covered it already, and I apologize getting the horse before the cart. So the answer is no. If it's a pre-service denial, you should be filing your pre-service appeal. If it's a denial or reduction by explanation of benefits of services that have been approved after the fact, then that would be a post-service. If you want to be extra safe, you can do both, but you're not required to. So again, if it's a pre-service denial, pre-service appeal. It's got to be within 30 days. If it's a post-service payment that's been authorized and they just didn't pay correctly or didn't pay at all, then you should be doing a post-service appeal. All right, next question. All right, kind of related. When do I send an appeal? So for the pre-service appeal, they have to be sent within 30 days of your receipt of the denial. So you get the response back. We had it reviewed by our physician advisor, and we don't think it's medically necessary, reasonable, not consistent with whatever denial they feed you. You have to, within 30 days of receiving that letter, file your appeal. Now, there might be arbitrators that say, yeah, I went over a day or two, you substantially complied, but they're probably going to argue in arbitration that it's too late, and therefore your assignment of benefits invalid and you can't proceed on your own. In terms of post-service, the only thing that the regulation says is it must be 45 days prior to filing arbitration. Sounds good. The bad news is Adobe, even though they were supposed to have a unilateral appeal process, have approved different decision point review plans for each insurance carrier, and some also have a limit of how long after you receive that reduction or denial that you have to appeal. So some of them say up to 180 days after you receive the explanation of benefits, you have to, and of course 45 days outside the filing of arbitration. Others say 90 days, some say 60. I believe there's maybe 1 or 2 that says 30 days. Within receipt of that explanation of benefits, you must be filing that post-service appeal. Again, to be safe, to cover yourself for both pre-service and post-service, send them out immediately, but at least within 30 days. I know it's asking a lot, but again, it's about protecting your bill and your services. Let's see what else. Question is, should you appeal and then immediately send it out to your attorney for arbitration? And when I say your attorney, hopefully it's me. I would say no. What I would recommend is file that post-service appeal, if it's a post-service appeal issue, diary it for 45 days, and then on the 45th day, send it out to the attorney if there hasn't been payment. Now, hopefully they'll pay you within that 45 days. Chances are they're not going to change their decision. The problem happens is if your arbitration gets filed under that 45-day time period, even though it might be valid, if it does get filed under that 45-day period, you're going to get bounced in arbitration, or could get bounced in arbitration. They're arguing this a lot now. I've seen it multiple times. And I've had some times where the file comes in, I see 1 or 2 appeals, it looks like it's a good file, no problems, but there's later dates of service that haven't been appealed for at least 45 days. So to be safe, keep it yourself until that 45 days is up, diary it, and then send it out to the attorney, the law offices of Sean Hagan. Now you can send these arbitrations to me at my address, my email address, through the portal, through fax, whatever way you need to be. Also, if you have questions, like I said before, email me at sthaganlaw@gmail.com or fax me at 732-722-2911. And of course, you can always call me at 732-722-2911. The fax is 2912. I apologize. Next question. What if I fail to appeal? Are my services denied forever? So the answer is no, they're not denied forever. What failing to appeal does is it takes away your assignment of benefits. So you can't proceed to get your bills paid on your own. You then have to contact the patient directly and or his or her attorney and have them file direct action. Now that may take additional time because they have to be careful to include all bills in their arbitration. They can't just pick yours out if there's any other medical providers who have outstanding bills. So it doesn't mean it's a complete bar if you don't appeal, but if you want to proceed for your own sake, make sure you're appealing timely and properly. And where do I send them? Can it be required by email? So as I mentioned before, each plan in it will say where you have to send it. Some say they're required to have either an address or a fax number. Some have both. Some have, and many plans have different numbers and or addresses, whether it's going for a pre-service appeal or a post-service appeal. So make sure you're sending it to the correct fax number or address. Now, one insurance carrier unfortunately had only an email address for their pre-service appeals. I brought this to the attention of Adobe. They were supposed to look into it and get back. I don't think they ever did, and I still think that plan is current approved. The problem with that is, in order to have an email, they have to make sure, the insurance carrier must make sure that they have a secure and HIPAA compliant email address along with a server. And when I contacted this insurance carrier, they couldn't guarantee me both and said, well, you can send it by fax, and gave a fax number. Unfortunately, though, this same insurance carrier in arbitration is now arguing, well, you didn't send it in through email, therefore it's invalid. I have that case pending. Hopefully the arbitrator agrees with me in that you can't require it. So not only does the insurance carrier have to, but you have to protect yourself. You have to have a secure email address and server in terms of sending any medical records so that you don't violate your responsibilities and your duties under HIPAA. So I don't believe they can. If you have a secure one, you want to take that chance. Otherwise, I would suggest for that particular carrier, Progressive Insurance Company, to call them, say, look, I can't send it by email. I want a fax number. And if they do give you a fax number, get it in writing, saying that you have permission to send it via fax. Because, of course, come arbitration time, they may argue the contract. So I think that's all the questions we have that I have that asked to be addressed. As always, I'm here if you have other questions. Again, feel free to contact me. I'm often speaking to doctors and billing agents to deal with this appeal process and any other issue dealing with New Jersey PIP. Hopefully it'll go well. Hopefully the arbitrators will rule, taking into account that treatment shouldn't be delayed and that your bills should be getting paid, and not allowing insurance carriers to argue technicalities and when they're not paying the services. All right, so for the monthly drawing, if you're aware and you've been watching my videos, each month those who are members of the Hagan Professional Information Program, and anybody that sends me any letters, phone calls, faxes, sent me questions on this, anybody who's sending me demands for arbitration so I can recover your PIP at no cost to you, I enter them in the drawing each month and draw for a $50 gift card. If you don't win this month, you can always win next month, so keep sending those correspondences and those claims for arbitration. Okay? And this month, the winner is Patrick Franklin from South Jersey Health and Wellness. Congratulations, Pat. I know I just spoke to you the other day, so I'll get out the gift card very shortly. Again, for those who didn't win, there's always next month, and keep them coming. Well, hopefully that'll help you with your appeals process, but as always, we're here if you have any questions. If you found this video helpful and informative, please like, share, and subscribe to the links below. As always, I'm never too busy for your kind PIP referrals and personal injury referrals. Have a very happy Thanksgiving. Thank you, and God bless.